Good morning and welcome to Eko Club International webinar on immigration. I am a member of Eko Club International. My name is Oluwafemi Sola Igbalajobi. And with us today, we have two prominent attorneys who will be helping us. They are Dr. Oluwaseku and Chris Agocha. I will have them introduce themselves after I've introduced our national president, who is also here and will be giving us the opening speech. On this line with us is our national president, Chief Saeed Olushi, and I will give him a time to just introduce us briefly, and then from there we'll go on. Thank you. Chief Olushi, please.
Distinguished members of Eko Club International, blessings everyone. I would like to say good morning, good afternoon, good evening, wherever you are, to all other distinguished guests, our panelists and participants. My name is Saeed Olushi. I am the current president of Eko Club International. And to those of us who are not too familiar with Eko Club International, we are the umbrella diaspora organization for Lagosians for all Lagosians, I would say. And there's no way we can say we are Lagosians or we are the umbrella organization for diaspora Lagosians without showing concern and empathy when it comes to an issue as sensitive as what we are dealing with currently in the country. And that is why Eko Club International came together to organize this important webinar. It is an honor to address us today as we all come together and participate in this webinar. As we all know, immigration policies are evolving, especially in the United States of America. And the evolution of these policies are not just impacting individuals, they are impacting families, they are impacting like the whole community of immigrants. By extension, it's affecting people's careers, people's health and businesses. And sometimes we don't even know exactly what the future have for us. And that's why we've heard so many conflicting information. Some are really terrifying. That's why we feel that it's important to have professionals address these issues and consequently also answer whatever questions you might have, so that if in any way we are impacted by this policy, we can at least have professional guidance and then know exactly what to do. Today's session is designed to be informative and interactive and also empowering. And that's why we have experts like Dr. Ashekun, and I do not want to pronounce your name incorrectly. I have Dr. Oluwashekun and also Chris Agocha Esquire. Thank you so much for joining us. Thank you for sparing your time. We know you are very busy professionals, and we appreciate that you're able to, join us today and, to discuss these issues that are of importance to all of us. We believe in the power of collaboration and knowledge sharing in uplifting our communities, and that's why we're here today. Ladies and gentlemen, let us take the time to listen to our professionals. And at the end of the day, whatever questions we have, I am very confident that they'll be able to address those questions. And once again, I welcome you all. I look forward to a productive and enlightening session. God bless you. Blessings.
Thank you, Mr. President. Thank you very much. Now we're going to the meat of it. I'm going to have the two attorneys to introduce themselves. After the introduction, I will come in and then state the various things that we have made available within how you can communicate with us and everything. And then I'll give it to them. They will talk about, they'll just give a general gist of all these things that are happening and advise us all. And then we'll take the questions. Thank you. Let me start with my very good friend, Dr. Oluwasegun. Please go ahead, introduce yourself and
Thank you, Honorable. Good morning, everybody. My name is Olu Ashekun. I practice immigration law, and my office is based in Arlington, Texas. I've been doing this for some decades now, and to God's glory, we have been able to help a lot of people. So, welcome. Thank you.
thank you, Dr. Oluwasegun. Chris, can you go ahead, please?
Yes. Good morning, good afternoon, good evening from wherever you are listening or watching. My name is Chris Agocha. I'm an immigration lawyer that is based in Washington, D.C.
Thank you. So the rules of the game is we basically brought up a system in which nobody knows who's asking the questions. Nobody sees anybody except the few of us who are involved. So don't be scared of anything. Nobody's seeing your information. Nobody's there. You want to ask any question, you go ahead in the chat box, put your question there. You can have chats, put your question in there. I will advise don't raise hands because if you raise your hand and we call you, you are going to expose yourself. We don't know anything. We don't want to get anybody uh, into any trouble much later. You talking about something that did not happen, and we cannot actually validate that it happened or not. So write your questions and we'll ask the lawyers. But I'm going to give the two of them time to talk about all the things they've had, talk about what they've done because they are masters in this game. So let me start with Dr. Ashekun. Please go ahead, give us a spiel about all these stories we've been hearing and all that. How we can be inform us very well. So some questions will have been answered during the information session. Thank you.
Thank you again, and welcome everybody again. Immigration law is a little complex, and because of these complexities, it allows for rumors and allow for misinformation. Uh, while the first thing I want to say is that the new administration has not enacted any law at all. It is the existing immigration laws that they are enforcing. In fact, I can tell you that between 2016, when during Donald Trump's first administration, and now, no major law on immigration has been passed by the Congress. The only thing that has been changing back and forth is enforcement. It is the same law that was in existence during George Bush. It is the same law that was in existence during Obama. It is the same law that was in existence during Trump's first term. It is the same law that was in existence during Biden, and it is the same law that the current administration is still enforcing. The only thing that has been changing back and forth is the enforcement. What is the enforcement differences? Some administrations, especially democratic administrations, they have always been enforcing immigration law with compassion. That is what makes the difference. That is why, for example, during Biden administration, they have a policy that if you do not have criminal record, you should not be deported. That was their own policy. But again, that doesn't mean that the law that says that people who entered illegally should be deported, it doesn't mean that the law was not there. It was just that they were enforcing it with compassion. However, the new administration, they have decided to enforce the law the way it is written. And that is the basic differences between all these administrations. So it's not as if Trump has passed some new laws, as some people are circulating online on social media, all kinds of things. In fact, this morning, somebody sent something to me, a video of one at AI saying that Nigerians should not send money to Western Union, all kinds of things. Of course, in the last few weeks too, we saw the video about some people saying Americans with dual citizenship, they cannot travel, all kinds of misinformation. All these things are complete nonsense, and they are not true. They are not true at all. So the basic thing, the basic information provided by the authorities themselves is that there are going to be 5 categories of enforcement. If you are within the 5 categories, then you have something to worry about. But if you are not within any of the 5 categories, then you don't have anything to worry about. However, let me first state the 5 categories, because I also want to allow my brother Chris to give introduction. So the 5 categories: 1, people who enter the United States in the last 2 years unlawfully through border. Those of us who have been here for some time, you will recall that I think it was in 2022 or 23 when it was as if the border was open. Everybody was just coming in. Everybody was just coming in, to the extent that the governor of Texas at the time had to arrange a bus, and they were sending these people to places they considered sanctuary cities. They were sending people to New York. And I remember the mayor of New York at the time was complaining that the federal government needed to come to their assistance. So all these people that came in without visa in the last 2 years, that was the information that was given to us. But when I saw the memo that the new Attorney General wrote, she actually included in the memo that in the last 4 years. The memo originally was presented before the new Attorney General was sworn in. But when the new Attorney General was sworn in, her own memo that she wrote on February 5 actually stated 4 years. So if you entered unlawfully in the last 4 years and you have not done anything to regularize your status, yes, you may be at risk of being arrested. The second category, if you have criminal record, if you have been convicted of any crime, you are at risk of being arrested. In fact, this week, and I think it was on Tuesday, this week, I had a bond application of someone who was arrested, and I attempted to get him out on bond. This person has been in the US for 40 years, 40 years. And he was arrested in January for DWI. That is driving while drunk. And of course, the judge denied the bond. Despite all the equities we presented, the judge denied the bond on the ground that he is a danger to the community because of the criminal conviction. So if you have criminal conviction, yes, you have a reason to be concerned. That is the second category. The third category is anyone who entered the United States at any time illegally, whether you went through the border, whether you jumped through the fence, whether you jumped through you swim, or however, for as long as it is illegal, you are not inspected, yes, you are in the category. The fourth category, anyone who has a removal order. If you have a removal order, if a removal order has been issued against you, either you know about it or you don't know about it, you are at risk, because it is possible for somebody to be removed in absentia. If you file something and the thing was denied and they place you in removal proceedings, and maybe when they mail you notice of notice to appear or hearing notice, you have changed your address, or you didn't notify either ICE or the immigration court, they will go ahead and order you removed in absentia. So it is possible for you to be ordered removed in absentia and not know about it. So if you, in some cases too, you may also know about it. You may have been ordered removed. You may have even filed an appeal, and then the appeal has been dismissed. But yet you remain here because previous administrations have not enforced it because we didn't have criminal record. But under this new administration, if you are in that category, you are at risk. The last and the fifth one is anyone that is encountered by ICE. That simply means that they are not looking for you. But if for any reason they meet you or they encounter you, and then they realize that you are illegal, then you will be arrested too. What that means is that, let's say they are looking for Oluwaseun and they decided to come to my house. Then on getting to my house, they saw two other people. Of course, the first thing they are going to do, they will identify themselves. And of course, I will demand to see a warrant before I even allow them in the first place. But assuming they have the warrant and they are able to show everything, then they will ask every other person to identify themselves. So if these two other people, if they are not in legal status, even though they were not the target, even though they didn't come here for them, but because they are not in status, under the policy, they will still be arrested. That is the kind of people we refer to as being encountered. And again, let me just allow Attorney Chris to continue from here, because if I have to continue, there's so much to say. We all know that so many executive orders have been rolled out, and it is really, really funny. So, Attorney Chris, please continue, sir.
Yeah, yeah. Thank you, my learned friend, brother, Dr. Olu. Like you said, there is a lot going on in this new Trump 2.0, as we fondly call it. We are, grappling to keep abreast with all that is going on. And like my colleague said, all these things are still, there's no new law that has been, enacted by since about 4 or 5 years ago or 6 years ago. So most of them are being executive orders from one president to the other. And Trump seems to be more proactive, more stricter in enforcing all the laws than the Democratic opponents. But before I go on, I would like to, say that whatever thing that we're saying today or information we're passing is just for informational purposes, and none of them should replace legal advice, having to seek an immigration attorney if you have any issue that is bothering you. So all this is informational purposes and no intention to give legal advice to anybody. Recently, amongst other things, it's like, as I used to say, it's 1 week, one issue or more. So Trump keep coming up with all this. But lastly, in the news about this week, we heard about alien registration requirement, and most people have been, what does that mean? How do I get registered? Am I involved? Should I register? And all that nots. But the idea is for people who entered here, without registration, and they didn't have any registration when they were getting their visa. They just got their visa, they came in here, maybe they were underage. So now and it's been existing in the law since 1940 that requires airlines to register if they are here without registration so that the government will know who they are, where they are. So now Trump is resurrecting the law, is enforcing the law to make sure that people who are 40 years and above are registered, and who were never registered, who were never fingerprinted while they entered the USA, and they're going to stay here for 30 days or more. And the question has been, am I involved? Who are the people that are already registered? So there are several categories of people that are already registered that doesn't need to register again. And before then, let me say that the law is going to be, if you don't fail to register, there's going to be civil and criminal penalties for those who fail. Some could be about 5 years, about $5,000 or so, but they are still going to fine tune the details. So who are people that have already registered? If you're a lawful permanent resident, you're already registered. If you were paroled into the country, you're already registered. If you were admitted in the US as an immigrant, you have I-94 or I-94W, you're already registered, you don't need registration again. And then if you were issued an immigrant visa before coming to this US, and you already registered, you don't need to register again. And also, those who are in removal proceedings or deportation, they are already registered, they are not required to register. And then another group of people is those who received or who have received their employment authorization document, which is the work permit. They don't need to register. And then those who apply for green card with I-485 and all these other applications, whether they were denied or not, they're already registered, so they don't require to register again. And then those who, cross the border, but they have a border crossing card, they're already registered. So, but for people who are required to register, it's about 3 categories of people. Those who entered without inspection, they haven't been inspected, they just never paroled. Those are the required to register. And then also you have Canadian visitors who came in through the land border, port of entry, and overstayed. Without any evidence of registration, they are required to register. And then some of the DACA, that is DACA recipients who have never received work authorization permit and not registered. And then some TPS folks, they are all required to register. So that's in a nutshell about alien registration requirement that's been going on in the news. There are a lot of things that happened recently. There is a Trump gold card. There is, most people are asking, is immigration still processing petitions? Or so yes, they are. It might be slow because of changes or things that are going on internally, but they are still processing. So a lot is going on, but we can address that when we get your questions. So I will yield back to my colleague, to address some other issues before we take on your questions. Thank you.
Thank you. I want to say that if you have questions while we are talking, please start sending your questions so that at least we can start addressing the questions. It is possible for us to talk for the next hour or so and then not address your specific need. So the only way we can know your specific need is if you ask those questions. So if you have questions, send in your questions. Now, before I continue, I want to add to the issue of the registration.
Dr. Sekun, there is a question there. It says, please, is it now required for US or American citizens traveling to Nigeria to obtain a Nigerian visa on their American passport, even though they have a valid Nigerian passport?
Okay, before I answer the question, where did you see it? Because I was looking at the chat.
It should be coming to you as a panelist.
Yeah,
Oh, okay.
there's where you have a Q&A.
No.
Q&A.
The one that will be reading it, that's fine. I just wanted
Okay.
I don't the question. Yeah, I will come back to that. But what I wanted to add to the issue of registration is that what registration simply means, I think that word is scaring a lot of people. But what it actually means is that if you have ever at all applied for anything, either in the US physically or at the embassies, and you have been fingerprinted, you are in the US and you have applied for something where you have been fingerprinted and your pictures have been taken, that is what is called registration. So even if you enter illegally and you apply for asylum, once they send you fingerprinting notice and you have attended that fingerprinting, you have actually registered. So it's not a big deal, even though they make it look as if it's something new. It's something that some kind of registration where they have some register somewhere, you go in there and put your name. No, that's not what registration means. It simply means that if you have applied for anything and your fingerprinting have been taken, your pictures have been taken, you have actually registered. It's as simple as that. So that is what I wanted to add to that. Then I also wanted to add to the gold card. You see, the gold card is just a suggestion by the president. The president does not have the authority to enact laws. Laws are different from executive orders. So what the president suggested cannot be enforced until it is passed into law by the Congress. That is different from executive power. The president cannot issue green card by executive power. That is not possible. So the president does not have the authority to issue green card by executive power. But if the suggestion, if it is presented to the Congress and Congress pass it into law, that is when it becomes effective. So for now, it is just mere suggestion. So even if you have the money, don't assume that you are going to start having the opportunity to apply for a green card as a gold club member, as Trump called it. Now, to the issue of Nigerians applying for visa, I stated at the beginning of this program that there are lots and lots of misinformation. It is one of those misinformation. The US law requires that American citizens must go out of the country and enter the country with American passport. However, the same government, the American government, does not have a machinery, they don't have a system in place where Americans going out of the country are recorded or are inspected, or maybe they go through some form of program. No. So this exit is done through the airlines. So let's say you are flying American airline, or you are flying Delta airline or United to Nigeria, for example. So when you get to the airport, you give them your American passport. So when you want to check in, so you give them your American passport. So once they swipe your American passport and check you in, they return it to you, you have met that requirement that says you must exit with your American passport. Now, the agent, excuse me, the airline agent will go further to ask you, oh, you don't, when they look through your American passport and they don't see a visa, because they also don't want to violate Nigerian law by taking you to Nigeria without Nigerian visa. So they will ask you, oh, you don't have a visa, how do you intend to enter Nigeria? Then you bring out your Nigerian passport and show them that, oh, I'm also a Nigerian citizen. So you present it. American government cannot legislate on how somebody entered a foreign country. So it is not within the American government authority to determine how Nigerian government will admit people to its own country. So that is outside their authority. So for as long as you have presented the American passport to the airline, you have fulfilled the requirement of the law. So how you now enter Nigeria, that is the problem with Nigerian government. Of course, when you get to Nigeria, you present your Nigerian passport and you'll be admitted as well. So on your return, you also enter the US with your American passport. That is where you now have the opportunity to meet the CBP officials, and you present your American passport to them. So to answer your question, those things circulating on social media, they are complete fabrication. It is not true.
I have a follow-up on that, Dr. Asheku. Just for clarification, so if I am a US citizen and I have a Nigerian passport and I get to the airline and I have the two passports and they tell me, oh, they collect the Nigerian passport off of me without me telling them I'm a US citizen or anything. They see the two passports, but now they don't scan my American passport. On my way back, will I have a problem?
Let me say this. I've actually have a colleague of mine, a lawyer, on a program like this, on a platform like this, who shared his personal experience, which is exactly what he just said. When he was checking it, I think he presented both passports, and they swiped the Nigerian passport instead of the American passport. I will come back to that, but I want you to note my presentation. When you are traveling, present the American passport first. That was what I said. But this person presented both passports, and the agent swiped the Nigerian passport. So when he was coming back, of course, he presented his American passport to the CBP official, and the officer said, but what's going on here? It was recorded here that you are a Nigerian. And he said, well, you can see that I'm an American. You see my American passport. Then the officer said, well, I will need to update the record because it was shown that you are in Nigeria. So I will need to update the record. So the officer updated the record, gave him his American passport back, and admitted him in. That was his personal experience.
Thank you. Thank you for that. Go ahead, Chris.
Yeah,
I see you have answered the question.
Yeah, answered the question. This is just general. He kind of alluded to it in his opening statement. Most of the things that Trump is doing, if you follow him, both in his international diplomacy or relationship with other foreign presidents, he's trying to get into the head of people. So people are afraid. Some people would like to, or they don't want to be deported. They don't want to be detained for months before being deported. Some of my clients have been, coming to me asking me, is it okay to do self-deportation? Also, I said, no, you don't have to. So if you are thinking of that, you have to speak to an immigration lawyer and who will understand your specific situation and advise you on that. But let us not key in too much into fear mongering. Not everything that you hear. Some of them, like he said about the gold, the Trump's gold card. Getting a green card is in the immigration law. And if you don't change that, you cannot use executive power to, change the law to start granting residency, permanent residency or citizenship. So he's just floating those ideas to get people panicking and, get them talking. So that's his modus operandi. So in every situation, if you hear anything, just pick up the phone or go to a lawyer and get the exact situation. Most of the things that are out there is not entirely true. Thank you.
So there was a question you answered. Do you want to talk to that question so others can, because you just responded to the person. So others can know.
Yeah, somebody asked about the processing time for our applications. What I have learned, even before this Trump 2.0, is that the processing times they give out when you apply, depends. It's just for you to have an idea. It doesn't necessarily hold. some applications might have a processing time of 6 months, and it might take 2 years because of the backlog. So remember, Trump now is focused, even when he came in his first administration, he was focused on enforcement more than processing petitions or applications. So that caused a lot of backlog, which they are still trying to clear. That was why during President Biden's administration, he stopped kind of having people come physically for interview. If you file like marriage petitioners, if your application is tight, convincing enough, they will waive the interview and issue you a green card. Though under Trump now, every person now is required to appear for interview because they have a stricter scrutiny. So I don't really focus on the processing time we have. Because if I tell you it's going to take you 16 months and it takes you longer than that, you'll be like, I told you this. But I will just give you an idea, say, hey, look at what is going on. We don't know how. Ordinarily, this is what it takes, what the law says or what the guideline says that it takes. But now it could go longer than that so that to prepare your mind.
Okay, thank you. Thank you very much. I have a follow-up question to your presentation, and it's going to be scenarios that I had gotten before this meeting. Here's the question. It says, can you be removed after becoming a citizen because somehow before you got your citizenship, you had been in a removal status? Is that possible?
No, I didn't get the question.
Okay. Let me say this. I describe it because the person described it to me. Say in 1997.
No, you don't need to go into the details.
Okay.
I just want to understand.
Okay. Yeah.
Because you're a U.S. citizen.
You are a U.S. citizen now.
Okay.
But you had, before getting to become a U.S. citizen, you had a removal situation that you ran away, they didn't see you, and today you're a U.S. citizen. But you knew you were in deportation, but you moved state and all that, and they couldn't pick you. Can you now be removed?
There are additional information that I will need. I will answer the question, but I want to be as accurate as possible in answering the question. The additional information that I need is that, number one, if you are in removal proceedings and you are ordered removed, subsequently you apply for green card. So you will have to have changed your name for them not to know, for them not to link the two things. So the first thing, did this person change the name, change the date of birth, all those things? That is one. But straight to the answer, to answer the question, the answer is yes, that person can still be in trouble, because the only time a citizenship can be revoked is when immigration can prove that the citizenship was obtained by fraud. That is the only ground, except that somebody voluntarily relinquished it. Even if a U.S. citizen committed murder, which is probably the highest offense anyone can commit, citizenship cannot be revoked on that basis. And that is the first thing that came to my mind when this rumor started going, that some people were denying admission because they have dual citizenship. And it doesn't work like that. That's not the law. The law, citizenship can only be revoked if they can prove that citizenship was obtained by fraud. So in this case, this is fraud. That is why I was asking those questions. If the person didn't change his name or her name and went ahead, relocated to a different state, apply for citizenship and all of that, for as long as there's no fraud, if it is USCIS error, then the citizenship cannot be revoked. If it is their error for not connecting the dots. But if he changed his name, his information, his date of birth and all of that, and that prevented immigration from linking the two names, then that is fraud. Because in some of the applications, well, I don't know when this person applied for citizenship, or even green card. So I'm not going to use the current application to make a determination, because in the past, application for green card used to be only 4 pages. They don't ask a lot of questions. But there is still a question, even at that time, even in the 80s, there are questions like, have you ever used any other name? So it depends, how did he answer that question? If he said yes and put that name, then he has not committed any fraud. If it is immigration that failed to connect the dots, there's no problem with that. But if that question, have you ever used any other name? If he answered no, that is fraud. And let me say further, I actually have a case that I handle in this particular scenario. Somebody who came in from Nigeria a long time ago. Of course, in Nigeria in those days, when people apply for visa and they were denied, some people will go back and change their information, change their name, change their date of birth, repackage themselves, and reapply for visa again. This was what this person did. He applied for visa first time, they didn't give him. He applied the second time, they didn't give him. So he went to change his information, change his date of birth, change his name, repackage himself, applied again. This time, he got the visa. Then he came into the US with that new name. Now, he was able to go through the process and became a US citizen. Now, I think it was in 2013 when in Nigeria they introduced BVN. In his original name, he had a bank account at First Bank. So when, I think he has some money in that account, so when BVN was introduced, he went to Nigeria, provided the BVN, and so that he could have access to his account. Remember, BVN requires fingerprinting. So subsequently, he came back to the US, continued to live his life. After that BVN incident, his American passport expired and he needed to renew it. So he applied for the renewal. And in the course of background check and everything, I have no idea how the Department of State was able to access the fingerprinting in Nigeria. But the truth of the matter is that that fingerprinting in Nigeria showed up in his background check. And then he came up with a completely different name, completely different date of birth. So now the Department of State was concerned that was somebody attempting to steal this guy's identity, because this person is a US citizen. So they decided to forward the two fingerprinting to FBI Data Lab for analysis. So the analysis came back and they confirmed that these two fingerprinting, the one that was submitted for the BVN in Nigeria and the one that he submitted for his American passport here in the US, both of them belong to the same individual. Guess what? He was arrested and charged on 2 counts. Count 1, obtaining American passport by fraud. What is the fraud? He disclosed in his application that he has never used any other name. He has never used any date of birth. He has never been married, which is information he knew was false in violation of the law. I think they charged him under 18 USC something. I can't remember the exact statute. Count 2, obtaining citizenship by fraud. Of course, this person went to jail. So I believe that answered that question extensively.
Let me ask Mr. Femi, is this a true story? Because I've been, trying to, figure out in my head, how could this be possible when you have
now is a true story. Is my class?
No, I know. I mean the question that the story that originated that led to.
Yeah, I mean, it's a sample.
I'm wondering how that could happen. I know, it's clearly error on their part for them to have missed that, in your citizenship application and interview. But I would be more curious to, get to know more, because sometimes most of these people don't tell you the true situation that may have played a role in, one way or the other in what happened. But what my colleague just said is is how it happened. Once you obtain your citizenship by fraud, if anything triggers and they start investigating, you stand the chances of losing that citizenship.
Let me push you guys a little bit further. One question: can you be in deportation proceeding without your knowledge?
Oh yes, I said that before.
Yes.
That's called removal in absentia.
Absentia, yes.
How does that? How can that have happened? Or how can let me?
In my answer, you see, it is possible that at the time that they place you in removal proceedings, there is something called charging document, NTA, notice to appear. That is what normally originates removal proceedings. Nobody can be in removal proceedings without NTA, notice to appear. It is that NTA that will be filed at the immigration court. And once it is filed, then the immigration court will send you what is called hearing notice, that you have a hearing in this court on so date on so time. So the notice to appear too usually will have a date and time that you have been charged. It will list your allegations. Normally, it comes with about 4 to 6 allegations. Generally, allegation 1, you are not a citizen of the United States. Allegation 2, you are a citizen of so country. Allegation 3, you enter the United States on or before so date with authorization to remain until so date. Allegation 4, you remain in the United States beyond the period authorized in violation of the law, and then they will tell you what the charge is, and they will tell you to appear at the immigration court on at so place, so time, and so date. So if you have changed your address and you did not notify immigration that your address has changed, so at the time they mail out the notice to appear, it is possible that you may not receive it. But every non-citizen in the United States have an obligation to report their address change. If you change your address, it is your responsibility to notify immigration that you have changed your address. That requirement only does not affect US citizens only. It affects every non-citizen. So if you are not a citizen, you are required to provide a change of address. So if you don't provide a change of address and they mail the notice to appear and you didn't see it, then when the court will also send you hearing notice. And because your address have changed, you probably will not see it, because the court will also rely on the address provided by immigration, by ICE. So on the date of the hearing, the judge will ask the government lawyer, did you serve this person? And then the government lawyer will say, yes. Usually they mail notice to appear with certified mail. So they will provide evidence that it was mailed. Sometimes the evidence will show that it was returned, but it doesn't matter, because it is your responsibility to notify the court of a change of address. So once the judge is satisfied that the notice was actually mailed to your last known address, then the judge will go ahead and order you removed in absentia. So whether you know about it or not is immaterial. You will still be ordered removed.
And then just to add to that, if you later come to court and if you can show to the judge, clear and convincing evidence that either you did not get the notice due to no fault of yours or some reason that happened, the judge can go ahead and set aside the removal, but it's a very tough you have to overcome. So the hurdle to overcome. But 9 out of 10, the removal proceedings or the removal order will stand. So it's always advisable. I always tell my clients, if you move, notify immigration about your new place, your new address. You use the form AR11 to notify them, because the obligation is on you to always notify them, even if you're a permanent resident, like you said, unless you are a citizen. But anytime you move, don't fail to notify them, so that they will say, I know if once in a while, it slips through the crack, like I've moved and changed my office address. Immigration still send notices to my old address. Luckily for me, I have an online account, so I see most of the notices or some things that are coming to me. Otherwise, those notices or those letters, I may have missed them because of the error on their side. But it's a government. It's for you now to struggle to prove to them that you took all the necessary steps required by them and on you. Thank you.
Thank you very much. Just a question from what you guys have been discussing on this notice for removal. Is there a place that, because maybe some people now have green cards and things like that, but at some point they didn't know that they had an issue like you just described. Is there a place for them to search if they have a notice like that? That's one. In the past. And then if they do, is there a way that they can change the matter so they're not going to be in removal, or they have to go and do something else? Over to you guys.
Okay.
Okay. The first thing, and people who are watching us now can do it if you really want to get to the bottom of the thing. Go on Google. It's very easy. Or go on your web browser. Look for eoir.gov. eoir.gov. Once you click on it, it will ask you, it will remind you that this is a government website and all of that. Just admit, and then it will ask for your alien number. Even if you are a US citizen, for as long as you are a naturalized citizen, you are not born here, you also have alien number. So just put in your alien number and click search. It will tell you if you have a removal order or not. And it will tell you the date, the court that order you removed, and the address of that court. So it will give you that information. Now, whether you will be able to reopen the case or not, that is a different ball game. The only thing you can do to avert the situation is to file what is called motion to reopen. But whether the court will grant it or not depends on a lot of factors. Like I said, if you can show that, okay, yes, it is true, I changed my address, but when I changed my address, I completed Form AR11, which is Notice of Change of Address, and you have a copy of that form, and you even have evidence that you mail it to them, then that will be a sufficient a reason for the court to verify that you actually did not receive the notice. Because like Chris said, immigration makes mistakes a lot of times. Many times people will do a change of address, but at the time that immigration was going to send out letters, they will look at the application form itself. They will not look at the subsequent filings that were done after the application was filed. They are very fond of doing that. They go back to the application itself and look at the address that you provided in the application, and then they will mail something there. Instead of checking whether there has been subsequent filings, whether there have been a change of address, whether new address have showed up, they are not very good at that. They make that mistake. So if you have evidence that when you moved, you actually submitted a change of address, then you can get a lawyer who will help you to file a motion to reopen, and they will present all the evidence that shows that you didn't receive the letter. So if you are able to do that, then they will reopen the case. Now, if you are now already a US citizen or you already have a green card, usually you will file a motion to reopen and terminate, so that the court will just reopen the case and then dismiss it, so that your record is clean.
Okay, that's good. Let me add this to the address and how to keep tab. This recently, or about 3, 4, 5 years ago, or even beyond that, what they do now, immigration does now, is if you file a petition like I-130, I-485, when they are sending you the acknowledgement notice, they send you a code on a different letter. They send you a code that you can use to open an online account. Some people neglect doing that, but it's advisable for you to use the code and open an online account. It helps you to track your case. If anything changes, if there's any update, they will send you an email which will prompt you to go into your account and see the notices. Some people have failed to receive notices in the mail, but they have it online. They can print that and use it and act on that. So I advise everybody listening here, if ever you have such invitations, such codes that are sent to you, try and open an account and have an USS online account. It will help you to monitor your kids in real time.
So let me follow up on that open account. Most of us who came into the US at some point in the past, you try to avoid anything that will have your information with them, so that they don't at will just decide they want to do anything with you. So people try to avoid things like that. Are you guys now saying that it is also actually better to make sure that they have updated information about you and everything?
I don't.
Go
Okay.
ahead. Go ahead.
I don't think that's what it is all about. We're talking about missing notices that are sent to you. Remember, we started by having removal order entered against you in absentia. Maybe when you didn't receive the notice to appear in court and you didn't go to court, and the judge will go ahead and issue a removal order against you because you didn't receive. So now we got to a point. How do you keep track? So if I file an I-130 petition and 485 for my client now, in addition to the receipt notices that the USSCIs will send, they will send a code directly to the client, requesting the client to open an online account. That way you can monitor. They are not doing like to get more information to go. It is to your benefit to follow your cases, because sometimes you don't receive these notices. You can't believe the error, USCIS error, and then the postal error. But it's on you. Sometimes they have sent your green card, your work permit without you getting them. So by keeping track, once they take any action, once they take any decision on your case, they update it on the portal and send you an email. That email will trigger you to know, oh, we have approved your case. We are sending you your work permit or your green card in the next week. So you will be on the lookout. If you don't receive it after so and so date, that you should notify them. But if you don't have that account and you don't receive that mail, you will know that they have sent you a green card maybe over 1 year ago. I have a client who was in that situation. The green card was mailed to her house, and she didn't know. We keep looking for it everywhere. We didn't know that it has been sent to her. So I was telling her, because I went into my own portal, I saw that the green card has been mailed. He said he never received it. Apparently, they're sharing an apartment with somebody. Either they received it and they did big deal mail to him or her. So we eventually have to struggle to convince them that we never received that, because they don't want to issue either double work permit or double green card. So after convincing them that actually she didn't receive it, what they did was to cancel the one that has previously been issued and reissued it, but that took a lot of time. So to save yourself from those, it's advisable for you to, when you get that code, for you to register, open an online account where you can monitor and track your matter in real time. Thank you.
In addition, Solar, you have to understand that the entire world is changing.
Yeah.
If you look at the history of the United States, immigration pre-9/11 is different from immigration today. One of the major reasons why 9/11 attack was successful was because of the way the country was at the time. This is a free country. Nobody care about what you do. For as long as you don't commit a crime, you can do whatever you like. But things have changed since then. In fact, there used to be a time in Dallas here where we file green card application for people, and we go into immigration office and request an interview the same day that we file the application. We will complete the form from my office. We will take it to immigration office. We will attach the payment receipt. give it to them physically, and request that they be interviewed that same day. And then we get the green card in the mail within 3 months. All those things used to happen in this country. But things have changed because of terrorist attack and all of that. I tell people all the time that terrorists did more damage to innocent people looking for survivor than to the government that their intended target is. Because things change, a lot of course, you can't expect the government to fold their arms and not protect themselves. So they came up with a lot of new technologies. So even if, going back to your word, even if you are afraid that you don't want the government to know where you are and all of that, registering alone will not prevent that. Providing your address will not prevent that. If you, in today's America, there's something called public record. If you have a phone, it's public record. If you apply for a driver license, it's public record. If you go online to purchase something, maybe you go on Amazon.com or something, it's public record. If you buy a car, it's public record. If you have an insurance, it's public record. If you marry, it's public. In fact, in Texas, I don't know about other states, police no longer ask people for insurance. Because once they pull your vehicle, once they turn on the light behind your vehicle, they already have access to all of your information, including your insurance. So technology has advanced. So not providing your address does not stop them from knowing where you live in today's world. So it doesn't really do you any good. So it only gives you a benefit, like Chris said, of not missing valuable notice that was sent to you.
Wow.
To add to the public record, just walking down the street, they have photographs. If you haven't taken photographs, or if you need a picture of you in the last year or so, just call them in DC. They will send you a picture. You walking from one street to the other. The cameras are everywhere. So just coming out is a public record. You can't hide in this country. 9/11 changed a lot of things, for the way America thinks and reason or does things today.
I mean, have you not noticed that when you get in your car, your phone will tell you 15 minutes mile.
15 minutes miles.
How does your phone know your house?
So they know where you are if they want to get you. That's not the problem. So registering will benefit you more. They're not trying to get. And meanwhile, mind you, this is for people who either just arrived in the process of adjusting or changing their status, or permanent residents. They're not going after people who have been here, who are citizens or so. It's just so that they can, one, receive notices, or they can know where to get them at any point in time. It's for security purposes. So I will advise, if you get that notices to register, please go and register, open an account, online account. It will help you, to monitor your cases and take actions as needed. Thank you.
Oh, well. Thank you very, very much. I see no questions. I don't know if anyone online, if you have questions, there's the Q&A button that you can use to ask questions. You can also, in the chat, you can post your questions. Like I said, nobody sees who posted the question, so don't be scared. And our lawyers just told us we're only scared for nothing, because everything we do is public record. You walk on the road, it's public record already. So let's if you have any questions, this is an opportunity for you to be able to answer them. Everything I had that was sent to me had asked.
There is a hand up. I see one hand up.
Yeah, let the person go ahead. Maybe you unmute the person and let him go ahead.
Yeah, SM Classic. You are on.
You are on, go ahead.
Just unmute yourself. Well, we can't hear him. You are unmuted, so you can go ahead and talk. SM Classic, you have the floor. Okay. Maybe he posted it. Okay.
Well, in the absence of any question, maybe we can just talk about immigration generally. One question that I always receive in my podcast, especially from new entrants, is what can we do to legalize our status? And another question that I always receive almost every time are questions on asylum. And of course, talking about what we can do, I know that that's an open check, but I will start. Then maybe Chris can also add to it. There are basically three ways of getting green card or getting legalized in the United States. And there are two types of visas. We have what is called immigrant visas and non-immigrant visas. Immigrant visas are visas that are permanent, that is green card. Non-immigrant visas are visas that are temporary. Any visa with an expiration date, temporary. Maybe H-1B visa, religious visa, B-1, B-2 visa, F-1 visa, J visa, O visa, P visa, all kinds of M visa, all kinds of temporary visa, any visa that has expiration. Maybe they tell you valid from 1st November 2025 to 1st November 2028. That is a non-immigrant visa because immigrant visas are permanent. They don't have expiration date. So for non-immigrants, if you enter the United States as a non-immigrant, in order for you to be able to change your status, you must be maintaining legal status at all times. At all times. If once you are out of status, you can no longer change your status. There will be nothing to change to. If you came in as a B1, B2 visitor, for example, and at the port of entry, they gave you 6 months at the port of entry, it means that you are legal here for 6 months. So if you are going to change or extend your status, you will have to do it within that 6 months. Once the 6 months is expired, you can no longer change your status, and you can no longer adjust your status through employment routes. Now, that is non-immigrant. As for immigrants, like I said, there are 3 types of immigrant visas that you can use to stay here legally. One of them is called employment-based, and that is why we call it EB. EB simply means employment-based. So we have EB1, EB2, EB3, EB4, and EB5. Now, in addition to employment-based, we also have family-based. So for employment-based, there are numerical limitations. In fact, for every type of green card in the United States, there are numerical limitations with the exception of family, immediate family, with the exception of immediate family. Every single green card category have limits that are set by the Congress. So for the entire employment-based category, EB1 through EB5, the annual allocation is only 140,000 green cards for the entire world in those employment-based category. Now, out of that 140,000, EB1 will get percentage, EB2 will get percentage, EB3 get percentage, EB4 get percentage, EB5 get percentage. So that 140,000 is what is shared among all the 5 categories. Now, for family-based, like I said, immediate family is treated differently. The way immigration law defines family is different from the way that English dictionary defines family. So as far as immigration law is concerned, family of a US citizen includes the parents, the spouse, and children under 21. Anything outside that is considered extended family member. So if you have a child, your own biological child, who is 21 years old, as far as immigration law is concerned, that child is not your immediate family. The child is still your child, but no longer immediate family. The child has become extended family member. So for immigration purpose, immediate family, they don't have numerical limits. In other words, if 1 million American citizens decide today to petition for their immediate family members, immigration will have no choice than to process all of them. On the other hand, for employment-based, because the total allocation for all the 5 categories are 140,000 per year, if let's say EB1 gets 23%, and I think it's about 23%, if EB1 gets 23% of the 140,000, I don't know mathematics. I don't know if somebody can just use calculator to calculate 23% of 140,000. So but for the purpose of this explanation, let's say it is 20,000. Let's say it is 20,000, or let's say it is 25,000. If immigration under EB1, if they receive 50,000 applications, they cannot approve it. They will only be able to approve the 25,000 that is on the basis of first come, first serve. And that is what is known as visa being current. So if the allocation that is allowed by law is 25,000 and they receive 50,000, they can only approve 25,000 in the order in which they are received. That is what is called visa availability. Now, it means that the other 25,000 will go into backlog. Now, the following year, again, the law has not changed. They can only approve 140,000 for the entire family employment base, and let's say their own allocation again remains 25,000. If 100,000 application came in, they cannot even approve any of them because they still have 25,000 backlog from the previous year. So they will go into that first before they can even. So all the 100,000 applications coming in, all of them will go straight into backlog. And this is why backlog keep growing. If we apply the same thing to family-based, again, like I said, non-immediate members are considered extended family. So from the allocation for family-based, non-immediate, the total allocation per year is 226,000 per year for non-immediate families. And that non-immediate family includes unmarried children of US citizens. Unmarried children of US citizens. That 226,000 also include permanent residents who are filing for immediate families. It also includes permanent residents who are petitioning for unmarried children of permanent residents. It also includes married children of US citizens. And finally, it includes siblings of US citizens. Now, imagine all those categories having to share 226,000. You see why the visa bulletin keeps growing and why backlogs keeps growing. So that is the basic reason, one of the major differences between a US citizen petitioning for immediate family and US citizen petitioning for extended family member. That is the basic thing. So I don't know if we have time to go into each one of these individually, EB1, EB2, EB3, EB4, EB5, or even go into F1, but I will allow Chris to also talk before we continue.
Thank you.
In the meantime, if questions come in, please let us know so that we can.
Yeah, I'm watching it.
Professor Oluwasegun, you've covered the field. Yeah, there's a question, but I didn't understand what the person was asking. It's from SM Classic. It said, how I wanted to ask how long to fill a spousal visa. I don't understand. Could he talk, or could he clarify the question so that I can answer it?
I guess that's the guy that raised his hand.
Yeah, and
Yes.
we gave him opportunity to talk, but immediately we gave him, I think he dropped off.
Yeah, he's still here. I can see him, SM Classic.
So what's the question?
Okay, let me see if he has.
Okay, I think I see it now.
Okay, he's asking how long to file. I want 30A.
I want 30. I want 30A.
Okay. I think what you are asking is how long to file, because it says spousal, how long to file for your spouse, or how long does it take to file for your spouse? I-130A is a form used to get additional information. So you are probably asking for additional information of the beneficiary, which is the alien beneficiary, if you are filing I-130 for your spouse. All right, so you can file for your spouse if you're a US citizen or if you're a permanent resident, depending on your status. But I don't think there is any wait time to file for your spouse. Some people have asked me, when can I file for my spouse after marriage? I said, if you marry at 12 noon, you can file for your spouse at 1 p.m. or 2 p.m. There's no wait time, as long as your marriage is genuine and bona fide. I don't think there is anything in the rules that you have to wait for a certain period. That's why when you apply and you go for interview and they grant you a green card, if your marriage is less than 2 years, they give you a conditional green card so that you can come after 2 years to remove the condition. So that's a way for them to make sure that your marriage is genuine, that you're continuing to marry or be in a loving relationship with your spouse. So if you get married this afternoon, you can actually file in the evening. Nothing stops you from, as long as you guys are married. So even if you wait for 1 year, 2 years, it doesn't make any difference necessarily. The only thing is if your petition is approved 2 years after, more than 2 years after your marriage, then you'll get a 10 years instead of a 2 years conditional. That's the only difference. So there's no waiting period. If that is your question, there's no waiting period to file for your spouse. You can file for your spouse anytime.
There's a question.
Oh, sorry.
Okay, Dr. Olu, you can go ahead.
Question. A lot of our people, they want to eat their cake and have it at the same time. They want to get married and avoid the 2-year conditional green card. But at the same time, they want to get the benefit of getting green card as quickly as possible. You can't have it both ways. In fact, I've attended an interview with a client. They've been married for over a year before the petition was eventually submitted because, like I said, they wanted to wait so that by the time they filed, they would not get conditional green card. But during the interview, the officer asked them, "You have been married for a long time. How is this man who is not able to work? Why did you not petition for him? Are you not concerned that he's not able to get a social security number? He's not able to work? Because they can't disclose the under the table employment." So the officer was concerned. How are you able to manage? How are you able to take care of your family if you are not able to work and you have been married? The officer turned to the petitioner. You have the opportunity to get employment authorization for this person, and for over a year you didn't do it. How do you want me to believe that this is a real marriage? So I just want people to know that in an attempt to avoid getting conditional green card, you can actually run into trouble by thinking that these people are stupid. They are not, because it doesn't make sense. If this is a legitimate marriage and you have been married and you know that it is only when you petition that your spouse can get employment authorization, why will you not want to do it? Why will you want to be the only one working? Why will you not want your spouse's support?
Now, I have a question for you guys. This is what are the requirements or process of filing for adopted children from Nigeria?
Nigeria is a little complicated. It's a little complicated. And I can tell you, according to the statistics released by the Department of State, adoption from Nigeria, they have denied over 90% of their adoption application from Nigeria because people don't comply with the law. And of course, American government will not want to be a part in breaking the law. First and foremost, there are two ways of adoption. There is something called Hague Convention adoption. But unfortunately, Nigeria is not a member of the Hague Convention. So Nigeria is not eligible to do the Hague Convention. The Hague Convention is the easiest way of doing it because everything will be processed from here in the US. Now, because Nigeria is not a member, so I'm not going to go further into that. Now, let's talk about the other one that Nigerians can do. Again, there are two sub-ways to do adoption from Nigeria. So the first determination is, the person you are adopting, is that person an orphan? That is the starting point. Is the person an orphan? Because adopting an orphan have a different procedure than adopting a child whose parents or parents are alive. There are two different processes. So let's discuss adopting an orphan first. If you are adopting an orphan, if you are a US citizen, the first step is to apply to immigration, apply for what is called advance permission to be classified as an orphan. And then you file, I think it's I can't remember the name of the form right now. I can check it later, or maybe Chris can just please help me check it. I know it is one of the N form. Maybe it's not N600 because N600 is certificate of naturalization. So you file that to immigration first. But before you can file it, you start with what is called home. They will come and you get home study. That is the starting point. There are specific agencies that are recognized by the Department of State. So you need to find out. You don't just use any home study because that home study business is full of fraud. And almost every month, the government disqualify different agencies. Almost every month, there's a lot of fraud in that business, and the government is aware of it. But identify an acceptable home study company. That will be the starting point. So they will come, assess your house, make sure that you don't have criminal record, you don't have anybody living in that house who has a criminal record, you don't have people, you have enough space for the child. When you bring the child into your house, you will be able to take care of the child. You have the financial resources to do all of these things. So they will, at the end of it, they will write a report. That is what is called home study report. And you attach that to that application. So once the application is approved, then that is when you will embark on going to Nigeria to go and identify a child. Once you identify a child and that child goes through the process in Nigeria, you will now go to the US Embassy with that child and apply. They not normally, once they verify that everything is done normally, they will give that child an immigrant visa to enter the US. But upon entry into the US, they will issue citizenship to that adopted child. Now, because of child trafficking, even the Nigerian government have changed the law relating to adoption, because there's a lot of, like I said, there's a lot of criminal activities that is involved when you talk about adoption. I mean, some children are kidnapped and presented as orphan, all kinds of things. So I do know that the Nigerian government itself have changed the law relating to this. So you have to go through the court process. I'm not familiar with the exact current procedure right now in Nigeria, because I know it changed recently. I have processed adoption recently from Nigeria, but that is not something I can tell you in my head right now. If I was in the office, I would have been able to pull up a file and look at the recent changes. But I do know that there are recent changes. But the point is, you comply with the law in Nigeria, you also comply with the law here, and then you take that child to the US Embassy, they will grant an immigrant visa, and then the child will come in to join you here. But like I said, that is for orphan. Now, if the child is not an orphan, the procedure is different. You don't even need to do any home study. You don't even need to start filing anything with immigration here. You just go straight to Nigeria, follow the adoption process. Once you get a court order giving you that adoption over that child, you wait 2 years, because after adoption, the child must have lived with you for 2 years before you can apply for any benefit for that child. So after 2 years, you file I-130 petition the same way you will do for your own child. So once the I-130 is approved, USCIS will send it to the National Visa Center. National Visa Center will process it and then send it to the embassy. The embassy will issue an immigrant visa, and that child will be brought to the US. So that is the process of adoption from Nigeria. So I don't know if Chris wants to add to it.
No, that is very comprehensive enough. Meanwhile, for the form for advanced processing is form I-600A.
Yeah, I
That's
think
the
it's 600. I think it is the end thing that confused.
the confusion, and that one is for waiver also. So yeah, your analysis also is very comprehensive. There's nothing to add, but just to, because I have had this question, people coming to me, they want to adopt a child so that it's 17, 18, 20. I said, no, that adoption must be completed by the time the child attains the age of 16. So if the child is 17, is above 16, he has aged out. You can, people want to adopt somebody that is an adult already. I said, no, it doesn't work that way. It has to be done before the child attains 16 years old. So that's the only thing. But otherwise, yeah, once you satisfy the law in that country, whichever the adoption law is, you can apply for I-130 the way you apply for others. Thank you.
Thank you for that, because I was almost going to say maybe Dr. Oluwaseku can adopt me, I need people in America now need adopted. Hey, one question that is there.
Let me also, before you go to the question, let me also quickly add, there is one exception to that 16 age limit. If you are adopting siblings, if you have adopted a child who is under 16, and then you want to adopt the sibling who is over 16, then they may approve it, because you already have a sibling and they want the two siblings to live together.
To live together, exactly. Yeah, that's true. Thank you for bringing that up.
So this is regarding birthright citizenship. The question is, does either parent have to be a citizen or permanent resident at the time of childbirth for the child to be a US citizen?
No, only one parent.
And if the child is born here with it automatic.
The child is born here, none of them need to be a citizen.
It's automatic, it's territorial.
Okay. Except if Mr. Trump wins, because he's already fighting the case now.
Well, let's wait and see whether the Supreme Court will redefine rule of law.
So,
Or whether they will change the immigration, the law without going through the Congress, through the yes. It will take a long way to play out. I doubt if he's gonna win on that.
we are almost at 2-hour mark, so I want to, and no further questions coming in, and we've had a wonderful time with you guys. Dr. Oluwasegun, thank you very much. Chris, my buddy, thank you very much too. I want to, on behalf of Eko Club International, thank you guys for spending your time, and for information of those who are still on. We're not paying them. They are not paid, so people should not think they are being paid. That's why they spend their time. They just gave the time freely, and that's why we want to really appreciate them. So, on behalf of the organization, I say thank you. We're going to be having series of these. Oh, there's a question last minute. Oh, okay. I don't understand this question, but I'll read it. Maybe you guys can understand it. Please, concerning birthright citizenship, is it the kids that will be born after, or the kids are already born here? I don't understand, but
I don't understand it either. Is it one that was asking whether the two parents are U.S. citizens? Well, generally, any child, at least as of today, until the Supreme Court decide otherwise, any child that is born inside the U.S. or on any territory owned by the United States is a U.S. citizen. Well, it doesn't matter the status of the parent. That is the law as of today. But as far as children who are who are born outside the country, if one of the parents is a U.S. citizen at the time that child is born outside the country, then that child is also a U.S. citizen. They will just need to apply for passport for that child and social security number and all of that from the U.S. embassy. They have to report the child. They have to report that a child has been born for a U.S. citizen. They make that report at the U.S. embassy, and then the U.S. embassy will investigate it, verify that the child is actually born to that U.S. citizen. I've seen situations where they will ask the U.S. citizen parent to provide DNA.
DNA, yes.
Or they issue the American passport. So they do investigate it, but once it is verified, that child is automatically a U.S. citizen.
That's it, yes. I think that's
so
the question.
One question or request from people is, and I won't answer. I won't ask it like they asked it. They want information about how they can contact each of you. So can you post that information in the chat, and then we can copy it and post it to them, so that it's from you, not from us.
Well, we can do that, but let me also add that I do have a podcast that I do every single week. And this is not about Donald Trump administration. I've been doing this for years, even before Donald Trump came into office. So if you go on YouTube, we have a YouTube channel, or just even if it's on Google, just Dr. Oluwasegun podcast, then it will take you straight to our channel. We have discussed virtually every single immigration topic extensively. And like I said, we've been doing this for years. It's just our own contribution to humanity. I mean, I'm 60 years old, and I want to share some of my knowledge while I'm still around.
A question.
Yeah,
And
I've
I think,
posted it.
oh, are you answering it?
Oh no, I'm just seeing the question.
Okay. He's saying, is it allowed by law to travel to Nigeria with two passports, US and Nigeria, without a Nigerian visa? I think the attendee must have just arrived or joined us, because this was treated extensively with
Yeah,
examples too.
yeah.
But I'll let Dr. Oluwasegun give that person 1 minute to her.
Well, like you said, we have discussed, we have answered this extensively. Yes, US law. I can't remember the specific date that it changed, but I know that before, in the past, US law did not allow dual citizenship. But there was a year, was it 1940? I don't want to say something that I'm not 100% sure.
It's been a very long time anyway.
Yeah, I can't remember the exact year, but there was a year that this issue was litigated. I think they attempted to strip somebody of US citizenship because that person became a citizen of another country, and the person challenged it in court. And then the US Supreme Court ruled that no, there is no part of the American law that says that somebody cannot be a dual citizen. So dual citizenship is recognized and accepted by the American law. Yes, you can carry double passport.
Thank you very much. I think,
Yeah.
okay.
Let me say this. It's always advisable to, because every case has its own life, its own identity. It's always good to talk to a lawyer, an immigration lawyer in your area, wherever you are, about your specific case or situation. You don't always assume there is no way. In law, there's always, for every rule, there's always an exception. So you might think you don't have any exception or you don't have any answer to your problem, but once you speak to a lawyer and he gets all the facts, he can, in his own head, apply, knowing that, okay, this happened, that you might still be able to, get the benefit or whatever you're asking because of this exception or because of this thing. So it's always good to discuss your individual cases with your attorneys to get the sound advice. Somebody might come and tell you, I was just coming in, I was stopped at the port of entry because I didn't do this. I don't run with that. You have to really talk to the person to get what is that person's individual situation. And one thing that we didn't touch on here, which I would like to alert people, there is a travel warning. The American Immigration Lawyers Association has issued a travel warning. If you have a green card, your green card was, under 2 years, and then you applied for I-751 removal of condition, and it was denied. And maybe your passport was stamped with 1055 and you travel with it. Chances are you might be stopped when you're coming back. And then also, if you have a green card and you have either some sort of criminal proceedings or you were ordered removed and you managed to travel and you haven't been able to remove yourself, if you're coming back, they might stop you. So it's advisable that before you travel, if you have a green card or if you have a conditional residency, talk to your lawyer and then to advise you on, whether to travel or not. Don't just hop on the plane and say, yeah, go, I will come back, my matter is still pending. So that's why some people are complaining that they're coming back, they were stopped and their green card taken away from them, or they are not allowed to come in. That's the situation, especially in this Trump era. So always talk to your lawyer on your cases. Thank you.
Thank you very much. I think that's That's how far we're going to go at this time. And again, let me bring the president back to actually wrap up this session. Thank you, Dr. Olu Ashekun. Thank you very much, Chris. Mr. President, you have the floor, sir.
Yeah, again, Dr. Ashekun and Chris Agocha, thank you so very much for the presentation. I'm very certain that our members and the public at large have learned greatly from this session. I have also learned, a few things that I didn't know before. So we appreciate you on behalf of all the members and the leadership of Eko Club International, as well as members and families and friends who have logged in today to learn from your wealth of experience. We will continue to reach out to you in our bid to continue to make life better for our people. Again, thank you so much, and long live Eko Club International. Blessings.
Thank you, sir.
Thank you very much. Appreciate it.